16th lecture note. The title of this lecture note is Inheritance Law. We are going to look at this in four aspects. The first, general provisions of inheritance law. The second, testamentary. The third, inheritance by law. The fourth, acceptance of the inheritance. Let us look at the first aspect, general provisions of inheritance law. Inheritance law is a branch of law that is a system of legal norms regulating public relations on the transfer of property of the deceased or the testator to other persons, the heirs. The main source of inheritance law in Russia is Section 5 of Part 3 of the Civil Code. Under the inheritance, this means 1. Property, that is house, apartment, land, and so on. 2. Property rights, for example, any program created by the testator which he has copyright. 3. Obligations, by inheritance to pass not only the rights but also the responsibilities. For example, if a testator had a debt on the loan, then his heirs become successor in a promissory note, proportionate share of your inheritance. All of the above is called hereditary mass. The opening of an inheritance is the moment when the distribution of the inheritance mass begins. They can be 1. Death of a person. 2. Recognition of a person as deceased. Also important in opening an inheritance are 1. Time, that is, it is necessary to determine the moment when the person is deceased. 2. Place, that is, where the place of opening the inheritance, that is, the relevant legislation, if it is a foreign country and will apply to inheritance relations. The place of opening an inheritance is determined by 1. At the place of death. For example, a person went to another country and died, and the inheritance will be opened there. 2. By the location of the property, that is, if it is impossible to link the fact of death to a specific place, the place of opening the inheritance will be where the testator has the main property. Heirs can be 1. Individuals, that is, a person must be alive or conceived. The dead cannot inherit. 2. Legal entities, both private and public law, including the state, foreign states, international organizations. The concept of unworthy heir refers to cases where the heir has killed or committed any other illegal act against the testator. In this case, the heir is deprived of inheritance rights. There are two forms of inheritance by law and by will. There are two forms of inheritance, 1 by law and by will. If the will is not written and there are not heirs under the law claiming inheritance, the corresponding property becomes extortionate, that is, goes to the state income. Inheritance by will as the second aspect of our lecture note. A will is a notarized one-sided transaction that allows you to dispose of your property in the event of death. The will comes into effect from the moment the inheritance is open. The testator must express his will in the will. The testator must express his will in the person and have legal capacity. Wills drawn up under special condition, that is, being at sea, in a hospital, on an expedition, in places of deprivation of liberty, in a military unit, which are certified by the head of the relevant institution, the ship's captain, and so on, are equated to the notarized form of a will. The legislation of the Russian Federation is based on the principle of freedom of the will. The testator is entitled to bequeath property to any person to deprive any of the heirs at law, or even all of them, several of or all right of inheritance. To determine shares of heirs, to bequeath any property, that is, including that which he may acquire in the future. To include in a will any others, to cancel or change the perfect will. The only restriction on the testator's freedom of expression is the provisions of the law on mandatory inheritance shares. disabled parents, spouses, minor children, and other dependents of the testator inherit, regardless of the content of the will, at least half of the share that will be due to each of them in the event of the inheritance under the law. Then now let us look at the third aspect, hereditary succession. Inheritance by law is inheritance under the condition and in the manner determined by law, and not cancelled by the will of the testator. It takes place in the absence of invalidity of a will, or when part of the property remains unquested, or in the case where the heir to the will died before the opening of the inheritance or refused to receive it. The composition of heirs by law is determined by Chapter 63 of the Civil Code of the Russian Federation. They are divided according to the inheritance queues. The heirs of each subsequent queue inherit only when there are no heirs of the previous queues. Heirs of the same queue inherit in equal shares. Heirs of the first stage by law are the children, spouse, and parents of the testator. The testator grandchildren and their descendants inherit by right of representation, that is, the share of their legal heir who died before the opening of the inheritance, or simultaneously with the testator passes by right of representation to his respective descendant and is divided equally between them. Second line heirs are the testator full and half siblings. Their children, that is, the testator's nephews, nieces, inherit by right of grant. His grandparents, both of the father's side and on the mother's side. Heirs of third stage, or heirs of third line. Full and half siblings of the testator's parents, uncles and aunts of the testator. Cousins inherit by right of grant. The testator's great-grandparents and great-grandparents are called to inherit as heirs of the fourth line. In the fifth line, great-grandsons and granddaughters and great-grandparents and great-great-grandparents. The sixth line, great-great-grandsons and great-great-granddaughters, great-nephews and nieces, great-uncles and aunts. The seventh line, stepsons, stepdaughters, stepfathers, stepmothers of the testators. Let us look at the fourth aspect, acceptance of inheritance. Inheritance is accepted in the order of universal succession, that is, the heir passes in general all the rights and obligations of the testator except for those related to the personality of the testator, which are determined by law. It is not possible to partially refuse to accept the inheritance or accept it under a condition or with reservation. An accepted inheritance is recognized as belonging to the heir from the date of his opening, regardless of the time of actual acceptance or registration of rights to the property. Heirs are responsible for the debts of the testator jointly and severally, but within the value of the part of their inheritance that has passed to them. Acceptance of the inheritance is carried out by submitting to the notary at the place of opening the inheritance of the heir's application for acceptance of the inheritance or for issuing a certificate of inheritance. Such an appeal must be made within 6 months after the date of opening of the inheritance. It is recognized until proven otherwise that the heir has accepted the inheritance if he has performed actions that indicate the actual acceptance of the inheritance, in particular took possession or management of the inherited property, took measures to preserve it, made expenses for its maintenance, paid the debts of the testator, or received from. And with that, we come to the end of the 16th lecture. Thanks.